Hello, and welcome to today's Bloomberg BNA webinar. I have just a couple of announcements before we begin. First of all, thank you for attending today's presentation. Questions will not be submitted by telephone. Questions may be submitted at any time via the Q&A pod at the lower right of your screen. Simply type your question and click the icon to the right to submit. Questions will be allowed to accumulate and will be addressed towards the end of the presentation. You will currently see instructions on how to earn credits for attending today's webinar. If you have any questions about continuing education credits, please email us at credits@bna.com. In order to obtain HRCI, SHRM, and CPE credits for attending today's presentation, you must answer all polling questions that are presented throughout the webinar. There is no submit button for multiple choice questions. Your certificates will be ready to download in your classroom at learning.bna.com in the My Certificates tab, generally within 1 business day of the presentation. A copy of the presentation you're about to see, as well as instructions for downloading your certificate, can be found in the Files pod to the right of your screen. I would now like to introduce the speakers for today's webinar, HR and Finance Issues Managing Your Business During Global MA. Before we introduce our speakers, we would like to thank Global Upside for sponsoring today's webinar. Founded over 18 years ago, Global Upside provides HR, payroll, accounting, compliance, and staffing support in 100-plus countries. Our integrated services are backed by a robust HR technology platform, giving companies an end-to-end solution to manage employees globally, from making their first hire to expanding into multiple countries. Learn more at globalupside.com. I will now like to introduce our speakers. Christina McLaughlin is Intuit's Global Director of Human Resources, dedicated to mergers and acquisitions. For the past 8 years, she has represented HR in 50-plus of Intuit's M&A transactions. Her team participates in all term sheet and purchase agreement negotiations and leads HR due diligence, key employee offers, and HR integration separation planning. Dr. Clint Kendrick is Director of HR Merger Acquisitions at Oracle. Prior to that, he worked for an Alibaba-backed gaming startup as the Vice President of HR Administration, as well as leading HR, M&A, and global expansion for Boeing commercial airplanes. He has worked in human resources for two decades, where his expertise in areas related to global expansion, mergers, acquisitions, compliance, workforce planning, talent acquisition and retention, diversity and inclusion, and leadership development helps him guide teams of HR and business professionals through merger, acquisition, and divestment activity. Raghu Bhargava and his team at Global Upside help companies tackle accounting, payroll, HR, and compliance challenges in 100-plus companies. Raghu goes by the mantra, "Impossible is not in my vocabulary," and has helped Global Upside clients successfully navigate some of the trickiest business environments. In his previous avatars, Raghu was the CFO of Active Identity and held leadership positions in several companies, including Deloitte and NetIQ, where he helped the company grow from $20 million to $300 million in revenue. As discussed previously, there will be polling questions appearing throughout the webinar. Please take a moment to answer the polling question on your screen to ensure that you are comfortable answering the polls and to provide our speakers with insights to our program. Thank you so much for your responses, and I would now like to turn the presentation over to Raghu.
Thank you, Diamond, and welcome everyone to the seminar. As you all know, with the agenda, what we're going to cover today, and in terms of the polling question answers, looks like great majority of you have not done an acquisition, but obviously it is a challenging environment out there on the global front. M&A themselves are challenging, even domestically, and you throw in the complexities of overseas laws and things like that that are very different and unique to each jurisdiction, that presents its own level of challenges. With that, I want to get into my presentation. And the first thing I want to talk about is understanding the deal, because there's many ways to do an acquisition, from like stock or asset purchase. How do you pay for it? Are you issuing stock? Are you paying cash? Is there other things? Are there transition service agreements or TSAs? And what are the tax considerations you need to worry about? So talking about stock versus asset purchase, obviously you can buy a company by acquiring their stock, or you can go out and just buy the assets and possibly certain liabilities and the employees of that company. These transactions are structured very differently. They obviously result in very different challenges on the day of and the day after. Because if you do a stock purchase, then in most jurisdictions, the employees are just transferring over to become the employees of the acquisition company, acquirer. But if you're doing an asset purchase, yes, you can transfer the title to real estate or machinery or whatever it is that you're buying very easily, but transferring employees is not quite that easy, because what is happening is that these employees are then being terminated by the target company on the date of acquisition, and they're being rehired by the acquirer on the day of. What that does is that either the seller or the buyer may have to pay severance and things like that to all of these employees. Now, there are ways to structure these asset purchases where you don't end up having to pay severance. Sorry about that. But most times, the employees know their rights better than most times the buyers knowing what options they have, and they force companies into settling for paying severance and things like that. Now, the method of payment is equally important, because if you are paying in stock for stock, that might be an easy answer. But if you're paying cash, are there consequences? How will you move the cash from, say, U.S. as the parent company, as the acquirer, to, say, a foreign location? Or what are the consequences of moving that cash? As an example, many moons ago, I did an acquisition in New Zealand, and the sellers called and said, hey, you cannot pay us all of that cash in one tranche, because it'll actually move the market, and we will get less cash because the New Zealand dollar would bump up because somebody needed to buy that many millions of dollars. So these are considerations that you may not think about, because you're just saying, yeah, I paid X million dollars, so let me just wire it. But those can present consequences that you may not even know of. So keeping those in mind is extremely important. Also, earnouts. How do you calculate any earnouts if there is a future deferred payment based on meeting certain milestones, whether they be revenue or employee retention or growth or bookings or whatever that might be? So there has to be a lot of clarity around that, and part of it is how do you compute the earnout, and are there tax consequences of paying that earnout? Because in the U.S., typically, if you have an earnout payment, it is taxable income to the recipient. It would go on their W-2. But in other countries, you would have to evaluate it by jurisdiction as to how to tax or not tax. Transition service agreements, or TSAs, are very important, because especially if you're doing an acquisition or acquiring a division of a large company, because the large company may have a shared service concept, or they may not be selling you the local back office team, or they might not be selling you their ERP, HRIS systems. So how do you support the employees? How do you support the business on day 2 or day 1? And what most times it is very customary is to have a 6-month to a 12-month TSA in place, so the employees can continue to get paid, the business can keep running. But you also need to then think through, how do you manage to that end of TSA, so that as it is coming to an end in, say, 6 months from now or what have you, that you have rolled out your resources, whether it's implementation of a new ERP system or an HRIS system or anything like that, so that you're not going to get caught without having a process in place to manage your business on the 6-month plus day. Some of the key components you have to worry about is not just HR and payroll and accounting support, but also IT support, because obviously all of these employees were on somebody else's IT system and they may be cut off on day 2. So how do you get those people all activated? There might be leasing issues, there might be benefits issues, because the seller is wanting these employees to be off their benefit plans, but the buyer does not have the ability to put in the benefits. And sometimes it's an issue of, you in most TSA or in most acquisition agreements, you see where this buyer is promising that there will not be a significant change to the benefits of the target employees. But when you are spinning off, say, 5,000 people from a 100,000 person company, your buying power is significantly less, which means you cannot actually provide equivalent benefits. You may not be able to do certain things that a 100,000 person company can do. And so those have to be evaluated during the deal structure, during those commitments being made. And to the extent you cannot fulfill these commitments, how do you compensate the employees? So you're taking away certain benefits of these employees. Is there a compensation, cash compensation that can make up for it? Or can you provide them a different benefit that may be construed as comparable but not be the same? Obviously, tax considerations play an important role in it. Who's doing the acquisition? Where are they doing the acquisition? Where is the cash flowing from in case of a cash deal? Where is the stock? Which jurisdiction is the stock being issued from and stuff? Because now you're dealing with cross-country, cross-border issues, and and those issues are not very easy to solve. And also, many times what you're doing is when you're buying these companies, you are looking at how do you want to best structure this acquisition so it's a tax-efficient structure for you on an ongoing basis. So you may be buying this under a European umbrella, through a Cayman company or a Irish or whatever that might be. So there are a lot of options, and these are things where you do need to consult experts in these fields to get to the right answer. Moving on to the next slide. And there's the issue of ownership. So is the parent company, is that company going to directly hold the target, or is it going to indirectly hold the target? Or what are your plans post-acquisition so that you don't end up with 5 subsidiaries in UK and 3 in France and so on and so forth? How do you consolidate all of it on a go-forward basis? How do you move those people around? Is that even a possibility to do things like that? Obviously, from the target companies, the employee's perspective, the leadership structure is extremely important. Is our CEO going to stay or not? Is our management team going to stay or not? Who's going to report into whom? Who should I call tomorrow morning for because my annual review was due and now in the middle of this it is put on hold? How do we resolve all of that? And remember, if there is no clarity, it is not that you lose your worst people, it is that you will lose your best people, because they are the ones that can go out and get a job. And they are the ones that people are following up with because they know there is an acquisition of the company. They know there is most probably some level of uncertainty, maybe a high level of uncertainty. So the recruiters, other friends, and other managers from other competitors are calling them and saying, hey, look, you don't know what's going to happen, so why don't you come on over and start working for us? And that's the risk that all acquirers face, where you are having your best people walk out or not being retained in the proper manner. So that's the thing that you have to focus on. And then also from a go-forward basis, you have to think about how are you going to build your service centers? How do you run this business from day 2 onwards? or post-TSA, are you going to have a shared service center in possibly where you have the most people that you're acquiring, or are you going to assimilate them into your shared service center, or are you going to use some kind of an outsourced model where somebody can provide you certain levels of support, and the management of the acquirer is going to manage through that process and things like that. So the service delivery structure is important in that respect, and important to make that decision in advance, because if you decide to build your own or to outsource it, you may have to act on it much faster than anticipated, because it's not like it's already announced and everybody's waiting for it to happen so that they can jump in and help you. You have to stage all of this. So the delivery structure is as important as the ownership structure and communication. So the back office people, the people that have been supporting the old organization under the seller's organization, understand what is their role and how will it all play out for them. From a moving on to the next slide, from a people perspective, which is the focus of this seminar, the payroll and benefits are extremely important, because you obviously need to pay these employees on a very scheduled basis. In most countries outside of the U.S., payroll is once a month, so it's a little bit easier, but the once a month could be in 3 days, it could be in 30 days. And so that you have to worry about that. And also in many countries, there's a lot of issues around payroll. It's not just a matter of, hey, what's your gross pay? I can apply the standard deductions and I can make payroll happen. Because in most countries, there are a lot of benefits that are provided to the employees, some of which are subject to tax, some of which are not subject to tax. And so some of these benefits, even though they may not be subject to tax, may need to be shown on the paycheck and stuff like pay stub and things like that. So you have to worry about a lot of those issues around payroll and local quirks. Like I said, most countries only have once a month payroll, but if you are acquiring people in Panama, they are used to twice a month. Panama follows very much like an U.S. system. Countries like India, China, most other countries follow once a month. Obviously, I talked about benefit plans, and the benefits obviously have two sides to it. The statutory health benefits, pension benefits, things like that. The supplemental benefits, where you are being a little bit more generous and offering them better plans. But there's also non-insurance benefits, like gym membership, child care vouchers, meal vouchers. These are things that vary from country to country, and you need to make sure that those are in place, because the employees are expecting to continue to get their meal vouchers in Italy, as an example, because that's how they pay for their lunch every single day. So you can't just say, oh yeah, we are working on it, we'll get it implemented in the next 30 days. And from a transition perspective, from the seller to the buyer, there is a need for transferring the historical records of these employees. Like it says on the slide, in many countries, you need up to 3 years of historical payroll data to be maintained within the current employer's site, so that the authorities can come and inspect it at any time for any reason. And in countries like Brazil, there is a regular audit process, once a year audit process, that they come and inspect files of all the employees, and if you don't have them transferred over to you, you as the buyer can be in trouble. I talked a little bit about the core team and how they are coming over, a stock sale or an asset sale, where are you going to have to rehire them, or if it's a stock deal, obviously you're buying the company, then you don't need to rehire them. But to rehire them, then you need to incorporate a subsidiary in that country, across all countries where you have employees. and make sure that the subsidiaries are ready to hire these people on day one, and that you have the right employment contracts, the commitments. There might be seniority issues, things like that that you have to address. So even though they are becoming your employee today, August 8th, but obviously they worked for the predecessor for a long time, and do you vest them into their benefits as of their start date with the seller? Do you vest them in your as today being the start date of their seniority, things like that? And in many countries, seniority plays into social benefits upon retirement. So those are issues that you need to understand and address up front. Many times buyers acquire, say, 3,000, 5,000 employee division, but then they're going to go in and do a workforce reduction. So when you do these workforce reduction, you have to have visibility into the employment agreements, employment contracts, because without that visibility, you don't know what kind of rights the employee has, what kind of obligations the company has towards these employees. And you also need to think about the timing of the WFR. Do you want to do it on day 2? Do you want to do it somewhere down the road, say a month or 2 months or 3 months from now, evaluating people, who's the best employees to keep, who's not the right employees to keep, that kind of stuff. And those all play into your transition and termination clauses, because you may need to make some commitments to the seller that you're not going to do, say, a 50% layoff or a 30% layoff, that you can only do, that your plan is to lay off, say, 10% of the people or whatever it is. When you do a WFR, as an example, in India, when we do a RIF, we can just have a formula based on seniority and title as to what your compensation or severance might be. But in many countries, the severance has statutory and supplemental consequences. In countries like France, your marital status, your education status, your number of children, things like that play into it. So it's not just a matter of, hey, if you're a vice president, we'll give you 6 months and we're done. It may be 6 months plus something. And a lot of this has very extensive consequences. You may need to pay, say, a year or year and a half or 2 years worth of compensation to let somebody go, especially if they have a large family and they've been with the company for a long time. And before you can even do a WFR, you may need to worry about the impact of unions or works council or CBAs, collective bargaining agreements, because in many countries, these are very, very common, even in technology industries, even in non-manufacturing type industries, where we typically, in the U.S. as an example, we don't see unions or CBAs. And because what is happening is there's a lot changing, you need to worry about change management and how do you manage through that. And so you need to have somebody who's going to be responsible for it and deal with it. Moving on to my last slide, the day after close, and I've talked about a bunch of these things in terms of systems. So are you going to have an integrated platform where your ERP, your HRIS, and other systems talk to each other stuff? Are you big enough to have had those systems in place, or are you like a PE firm where you don't really have any systems, you just buy and then you build to support that? Do you need to add new systems because now you're no longer a 5,000 person company, now you're a 10,000 person company, so your requirements are changing? How do you do data gathering? How do you transfer? How do you move this data around the world? Because there are limitations on how you can and cannot do these things. And some of the speakers are going to talk about some of those data privacy and issues and things like that. There's obviously a list of systems that you need to worry about: ERP, HRIS, expense reporting, talent acquisition, employee portals, so on and so forth. And from an infrastructure perspective, will you be able to continue into the same facilities? Do you need to go out and rent new facilities? What kind of infrastructure do you need? How do you manage through that? And then the ongoing support really, is it all internal? You're large enough, like Oracle or Intuit, where you can build everything, you have everything, or do you need external because you don't have anything and you're a smaller company? or some combination of the two. And then the last question comes about is obviously who can help. And with that, I'm going to turn it over to Christina for her section.
Great, thank you, Raghu. Before we move on, I just want to remind people that you can type your questions into the Q&A box on the Bloomberg site. We're going to allocate a few minutes at the end for open dialogue. So please, as we're talking, if questions come to mind, feel free to type them into the box there. So I'm going to switch gears a little bit. I'm Christina McLaughlin. I'm the Global HR M&A Director for Intuit. And I'm going to talk a little bit about the employee experience and retention in global M&A. And as Raghu said, at the core, M&A transaction is really a complex change management exercise. You're managing people, your customers and your products through a very tricky change management experience, especially when you're dealing with a cross-border transaction. And as this little cartoon on my slide shows, there's three things I've learned are fairly universal around the globe around change. And the first is people don't tend to like it. Change evokes a lot of uncertainty and anxiety in your workforce. And that uncertainty and anxiety typically leads to either a temporary paralysis where everyone stops in their tracks until there's clarity, or, again, as Raghu mentioned, it can lead to attrition of some of your key talent. And so this is a topic that's not just important to the HR folks in the audience, but also the finance folks, because there's a very real cost to lack of employee engagement and attrition. So one thing that I focus a lot on in M&A transactions is planning for a good end-to-end employee experience. And at Intuit, we tend to put as much time and resources into planning for the employee experience and the change management process there as we do for planning for the product roadmap and the functional integrations and the customer integration. And it's not just about making a great day one experience for our employees when you announce the deal and you onboard them, but it's really thoughtfully looking at your deal value drivers and creating a plan for the 3, 6, even 12 plus months post-close when you're still coming together as one company and trying to get to achieve your deal value drivers. One thing I like to share this kind of funny little illustration with business leaders who are getting acquainted with acquisitions and maybe sponsoring a deal for the first time is that, focusing on engaged employees and helping them through this change experience is not just an altruistic thing, like we want everyone to be happy and enjoy coming to work. It really is, it's driving good customer experience, which also will grow your profitability of your company. So it's all a virtuous cycle, and it can either make the success of a deal or break the success of a deal depending on how those employees are moving through the acquisition and understanding the vision of why they were acquired and what they should be focused on now that they are part of this acquisition. So investing in that employee experience is important for the entire business cycle and to be able to grow as a company. Which leads me to my first polling question. So you'll see on the Bloomberg interface here, trying to make this a little interactive, so not just a monologue, but I want you to take a stab at responding to this polling question of companies that invest in the employee experience are how much more profitable than companies that don't. And you'll see a multiple choice question. And I think Diamond's going to pull up the polling box so that you can see the choices. I'll give people just a second. Right, so you guys are pretty astute. I think about 50% of the people polled are right on the money with this study that Harvard Business Review, you can close the poll, Diamond, or just put it to the side, but Harvard Business Review studied 250 organizations and said kind of those who invest in the employee experience versus those who don't, the average profitability they found is just over 4 times for companies that realize the importance of helping employees get clarity about their roles, and especially their roles after an acquisition. This delta between investing in employee experience and not is magnified when you're dealing with an acquisition, and obviously a global acquisition across multiple cultures. So there's a real cost to not doing it, and I've found that by paying too little attention to the employee experience and not for a long enough period post-close, it can really hurt your overall profitability or achieving your value drivers of the deal. So now that we have gotten to a place where our stakeholders are bought into the importance of investing in the employee experience and see the real business value of it, how do we go about, as the global M&A team on this call, how do you operationalize that? One of the first things I do with each deal is try to create a vision for employee engagement. An example of that could be in a large acquisition, within 1 year, every acquired employee is actively contributing, they feel valued, and they're inspired by the buyer's vision. It seems pretty simple, but you'd be amazed how many deals just get stuck at the onset where employees don't understand, why they were bought or what the purpose is for this acquisition. And anybody that's been through an acquisition and met an acquired employee knows that there's 3 questions every acquired employee asks. It's what about me, and what about me? And until you can kind of address that anxiety and the fear of the unknown by giving them clarity on what's your job going to be, and what's your salary and benefits going to be, who are you going to report to, how are you going to be measured, some of those basic questions, and it's kind of a Maslow's hierarchy of needs. Until you can resolve some of those questions and anxieties in your workforce, it's almost impossible to move on to a productive state and start working together on your new product roadmap or your new cross-selling opportunities, and again, just working together to achieve your value drivers. So I like to create a vision that's specific to each deal, because sometimes you're buying an acquisition and you're not going to immediately integrate, and there's only certain touch points that you expect between the acquirer and the target company. Other times it's really imperative to merge the two and become one team as quickly as possible. So that's why you customize this and make sure the entire deal team and your business sponsor and your leaders at the target are really bought into the vision of what you're trying to achieve, so that you can start creating a plan for your workforce that can get past that immediate, food, water, shelter stage of anxiety and really digging into what's the work we're here to do together. So to be a little bit more specific, this is a operating model that Josh Burson from Deloitte put together, and I've referred back to this in my own work several times to pull out ideas when I'm putting together my employee experience kind of roadmap. And I'm just going to call out a couple of things that I think are really important here, is explaining to people as early in the process as possible what's your new role going to be in the new company. So the meaningful work column. Especially when you're working with engineers and product managers and customer support folks, in knowing how their job is going to change from the day before the acquisition till the day after. It could be as simple as, when you, the day after the acquisition, this is how we want you to answer the phones. You know, you're now representing the new combined company. There might be a new brand, for instance, or for an engineer, you know, what's the product roadmap and what are the milestones and what are the operating mechanisms where we're going to all stay on the same page as we develop the integrated product. So as soon as you can make the transaction tangible for people and they feel like they have meaningful work, it alleviates a lot of that anxiety about the change that they're going through and whether this is a place they're going to stay and invest in. The other area I want to point out is the last column, building trust. So I find that the best thing you can do as an acquirer, no matter what function you're in on the deal team, is constant, transparent, and simple communications to people. Remind them, why we are acquiring the company. Remind them what the vision is of what we're going to do together, and don't leave folks wondering about what might happen. If there's going to be a reorg or there's going to be potential efficiencies that you're going to address through a RIF or product sunsetting, address that up front as much as you can so that people know what's coming and that it's not a surprise and they're just waiting for the next surprise to come down the path. And remember that, during this period of change, people will leave. It's quite common for attrition to spike during a large change like this and a global acquisition, which leads me to my next slide. Talking about attrition and what to do about it. So in an average company that's not going through a merger, you can expect on average 10% rate of attrition. Obviously this is quite variable based on what industry and geography you're in. But during an acquisition, the first year or two, that can spike up to 30% for your executives. And the surprising thing about this illustration is that your attrition can be twice as high for up to 9 years after the event. And there's a lot of cost to that, obviously, when you have turnover, and especially if you're losing some of your best people. So I want to just spend my last few minutes talking about what do you do to address, the inevitability of attrition and kind of mitigate that impact on your company. I think I lost my slide. Hold on. Clicked on the wrong thing. Hold on just a second. Okay, so which leads us to our next polling question. So when you're trying to mitigate the loss of key talent, what % of your deal price do you think you put aside as a budget for employee retention? I'll give people a few seconds to respond to that. Great. I think most people are, close to the money. So the median is about just under 2%. So it varies based on the deal size. For very large multi-billion-dollar deals, the rate is less than 2%. But on average, we're looking at about 2% of deal value. And when you look at trying to design a retention program in M&A, it really is a lot more art than science. There's some guiding principles that I want to walk through, but everything has to be applied to the specific situation of the deal you're doing. How many countries are you in? How many other opportunities for employment do your key talent have? Just what's the likelihood of them leaving? And then really taking a hard look at how long do you need to retain people for? What's your plan B if people do leave? And so a few things that I want to wrap up with and talking about there's a few best practices that I look at when designing a retention program in an M&A transaction. Being really thoughtful up front about identifying who that key talent is. And it shouldn't be driven just by people's titles and hierarchy in the org chart. You really should work with your deal team and your sponsoring business unit to say, where is that unique talent? Do we have any single points of failure where if this one person leaves, it would be really, really painful and hard to replace the knowledge, the historical knowledge, or the skill set that this person brings to bear. And make sure that you're really investing heavily in the retention of those unique skill sets. And think about number 3, the pay to stay versus pay to perform metrics. In 95% of cases, I'm putting retention in place in a pay to stay capacity, which is, time-based. It's very difficult, not impossible, but it's much more difficult to come up with performance metrics that you tie retention to, because there's very few things that are discretely within the control of the individual that you want to sign up for these retention programs. And so if they don't meet those performance metrics, you can get into some bad emotional situations with people saying, but it wasn't all within my control, so I should still get paid. Most of the retention programs I'm finding are, stay through a 6-month, 12-month, 24-month period. And the buyer just needs to be really thoughtful during that period of time that you are getting the transfer of knowledge that you need, but also that you are building up other people in the organization that can shore up any of these single points of failure in the organization that you might find. And lastly, don't forget to focus on things other than this retention money. Putting meaningful work and clarity around the purpose of that work, and lots of clear, repeated communication, things like that go a really long way to address people that are looking to potentially leave during this period of uncertainty. So sometimes those things are as or even more important than the money you can put in place to keep people. So with that, I'm going to hand off to Clint. He is going to talk about legal and regulatory complexities in global M&A.
Great. Thanks, Christina. So my name is Clint Kendrick, and I'm going to speak to 6 of the most common pitfalls U.S.-based employers face during cross-border M&A, and close with some tips for helping your acquisition and integration go as smoothly as possible. Just a few notes on my section before I begin. First, this really isn't designed to be an exhaustive list. These are just some key areas that you may want to watch. Also, I'm not an attorney. I'm just somebody who's done quite a few cross-border deals and run into issues, especially early on, due to my lack of experience. And I'm hoping that folks who've not done a lot of deals can learn from my mistakes. I'll also be sharing a U.S.-based perspective. And even though there are 196 countries on the planet, my emphasis during this presentation is going to be on Europe, with a little bit of commentary on APAC and Latin America. My focus on Europe is due to the frequency of transactions between the U.S. and Europe. I saw a recent Reuters article that said we're now at a 10-year high for transatlantic M&A activity, with roughly $200 billion in deals announced year to date. Most of those are between the United States, the United Kingdom, the Netherlands, and Switzerland right now. And we're likely to see some shakeup in the M&A space due to Brexit and the unknown consequences of that. So that's why I'll be focusing primarily on Europe. So starting off on financial matters, this is for the accountants. Those of you in HR, feel free to listen in. Be aware that there may be some different GAAP requirements in different countries. So when you're doing your diligence, make sure that you understand those differences in GAAP requirements from jurisdiction to jurisdiction. Those can sometimes come back to bite you. Other things to be on the lookout for are change in control provisions. A lot of times they're richer than what we see in the United States, and they often penetrate deeper into organizations. Some other things to be aware of, and this can be especially surprising the first time you run into it, is that there are some pensions and retiree medical plans that end up being carried as defined benefit liabilities. 2 that I've run into in deals have been the TFR in Italy. That's a mandatory retirement scheme. And then there's a retiree medical scheme that's required in several Latin American countries that are sometimes carried as defined benefit liabilities. And that can definitely change the accounting for a deal. Sometimes something that looked really good, once you start looking at those liabilities, can be a problem. Accrued liabilities, these are for things like vacation or sick time. can sometimes be significant. In some jurisdictions, the vacation time is use it or lose it. In other jurisdictions, it banks for a certain amount of time. And those don't always show up accurately on financials, I've found as I've looked through them doing my diligence in the past. And then finally, statutory contributions and mandatory perks can be really surprising and unexpected if you're not used to doing business in a certain country. So in Latin America, for example, we'll see requirements for meals or provision of child care. And that can get somewhat spendy when you're looking at cost of labor in those jurisdictions. There are also things that I'll call a cultural perk. While they're not statutory, they're not mandatory, there are expectations. And one of the big ones that U.S. employers often have problems with are company cars. It's not uncommon for executives in Europe to have a company car or to have their car paid for by the company, one that they purchase on their own. And that can be a surprisingly big issue when trying to integrate those employees. The next topic that can be a little bit surprising to U.S.-based companies is how the U.S. Foreign Corrupt Practices Act and to some degree the U.K. Anti-Bribery Act can cause problems or be somewhat surprising. While we're really unclear about how this will be enforced under a Trump administration, we do know that the increased enforcement emphasis that we've been seeing in the past decade and a half started under another Republican administration with President Bush and was carried through with President Obama. So there's no reason to believe that enforcement of the Foreign Corrupt Practices Act is likely to change in the next few years. There have been a total of 42 criminal charges filed against individuals between 2012 and 2016. So in that last 4-year block, 42 criminal charges against individuals, 39 against corporations. And this is because we have decided that essentially bribing foreign government officials is against the law, even if that's the way business is done in those countries. When HR comes into play, anything of value can be a bribe. So we often hear the phrase business courtesies when we train people on the Foreign Corrupt Practices Act, but anything of value can extend to hiring the relatives of a foreign government official. We saw a recent case with Chase Bank where a bunch of interns were hired. Well, these interns happened to be the children of major party officials, and Chase received a fairly significant fine for this hiring behavior, even though it was the norm in country. Since HR often owns the corporate social responsibility in some organizations, charitable contributions, things like donating to a party official's wife's favorite orchestra, which is something that I've heard about in the past, can be a violation of the Foreign Corrupt Practices Act if it was done as some sort of inducement. And then finally, there is some mitigating effect from having strong post-integration training and things like ethics hotlines. The Department of Justice has looked at this when looking at successor liability for M&A related incidents, and they have either declined to prosecute or lowered the amount of fines or the amount of the settlement when companies know that there's a problem, that something under the prior ownership wasn't quite right under U.S. law, and that training has been a mitigating effect. So we saw a recent case of successor liability with Goodyear. They had a minority stake in their operations in Kenya and Angola, and they bought more of those organizations. Well, those subsidiaries were found to have paid over $3 million in bribes to government officials. Those bribes ended up costing the company $15 million. So it was a pretty significant fine plus the lost value of those bribes. The best remedy under the Foreign Corrupt Practices Act really is strong due diligence and immediate implementation of training and ethics programs. So we're going to ask a polling question about the Foreign Corrupt Practices Act. And this is specific to the M&A related successor liability. So going back to 2002, past 15 years, how many anti-corruption cases have U.S. officials brought for M&A related successor liability? And your choices are 3, 12, 29, and 48. Give folks just a second to jump in here. Looks like we still have a few answers coming in. It's always nice to see an audience that's a little more paranoid than most of the folks I talk to. So we've got the bulk of the answers coming in at 48. The answer is actually 29, but that's still a really hefty number of cases for successor liability specifically. So that's almost 2 per year that we're seeing. So really, again, the cure for this is making sure that your due diligence is really strong, that you ferret it out when you can find it, and that you implement training programs where possible to ensure that that liability is minimized. The next thing I want to talk about very briefly are privacy laws. Different jurisdictions have different standards, and so if you're doing a multi-jurisdictional deal, you may have multiple sets of privacy laws that you're dealing with. The way that we look at this mostly in HR is around employee data, but for those of you that are working on big deals where there are multiple functions involved, realize that customer data also is subject to these privacy laws. In general, the EU standards are the most strict, and what they require is a legitimate need for the data, and the transaction might be a sufficient cause to gather employee data. Where individually identifiable information or sensitive information like health status, union affiliation, religion, sex, national ID, etc. is required, there is consent for the person. Consent is required for the person's data to be released. And then finally, there's a requirement that releasing the data is part of performance of a contract, so such as closing an M&A deal or working on integration. The EU regulations are changing. There's a general data protection regulation, which will be effective in May of next year. So this is a constantly changing landscape, and I always encourage people to consult an expert. The EU's getting pretty serious about this. They're firing warning shots. Just a couple of months ago, the Hamburg data commissioner in Germany fined Adobe Systems, PepsiCo's subsidiary Punica, and Unilever around $32,000 for failing to set up legal channels when the U.S. safe harbor laws were deemed not sufficient. And it's just a little bit of a warning shot. We expect to see that the fines for violations of these will go up, and M&A activity is really a hornet's nest when it comes to employee data privacy. So that's just another area to be aware of. So I'm going to move away for a moment from the things that the lawyers tend to talk about with compliance and move into some things around really how we manage employees. So the first is how we transfer employees. So at the beginning, Raghu talked a little bit about different types of deals and different deal structures. In general, a share sale will have no effect on the employment relationship. The employer of record remains the organization that was acquired. But when we start to look at asset sales, they usually trigger either an automatic transfer or a need to do a technical termination and rehire. And that's going to vary by jurisdiction. In Europe, where there's an automatic transfer, employees have acquired rights. That basically means that they keep their terms and conditions of employment, or there's some sort of harmonization requirement. Even if employees agree to changes in their terms and conditions, there are some places where the company can't make changes, and you'll want to consult with an attorney or an expert in that jurisdiction to see if your plan is going to work and make a lot of sense. You may also want to keep in mind that outsourced employees will often be considered employees of the acquired company, and so again, that's a jurisdiction by jurisdiction thing. I'm going to talk a little bit about information and consent when I talk about works councils, so I won't park on that here. But one other thing when you look at individual employment contracts is that in much of the rest of the world, restrictive covenants such as non-competes or non-solicit agreements are often unenforceable. So as you're looking at your employee population and thinking about putting those kinds of things into place, that can be a potential problem. So let me roll into the next polling question, and this is really about the consequences for violating European labor laws related to M&A transactions, and this is all about the transfer mechanism, information and consent requirements, and some other things. So our choices are reinstatement of employment in Austria, Hungary, and the Netherlands, criminal charges in Belgium, France, Italy, and Poland, or in Ireland, where violating these laws could result in 2 years of pay per affected employee. And for those of you that have followed along with these kinds of polls in the past, you know all of the above is the answer. So that's just to point out the severity of ignoring these labor laws. You really do that at your own peril. While criminal charges are not particularly common, any kind of egregious violation can result in those. And really the damage to a U.S.-based company's reputation for failing to follow local law can be much more significant than the financial and criminal penalties. Okay, I'm going to talk for just a moment about dismissals, and again, Raghu pointed to these at the beginning. We can call them any number of things: redundancy, retrenchment, layoff, downsizing, lots of different names for essentially terminating employees. And it's much more complicated in most of the world, where our U.S. concept of at-will employment is seen as candidly pretty bizarre. M&A alone is not a reason to downsize. So companies that go in expecting to cut X% of the workforce are usually frustrated in that attempt. You can cite other reasons, such as technical or business or solvency reasons, but those tend to take time, and immediate downsizing or dismissing of employees is not usually permitted. We already talked a little bit about the statutory severance and notice periods. The proper notice does have to be provided. Sometimes that can be done through a union or works council, but not always. Sometimes you can pay employees to do what they call garden leave, which means we're going to pay you to literally go work in your garden. But in some jurisdictions like Norway, an employee can fight the dismissal and has the right to remain on the job at their desk for as long as it takes to wind its way through the courts. And then finally, collective redundancies, that means mass layoffs, often have additional requirements such as consultation with the government labor ministries. So just be really aware of these kinds of requirements as you go forward. Also, there are jurisdictions where you have to have proper form. In Chile, for example, your dismissal has to be done in front of a notary to be valid. If you want to dismiss parts of your employee population in Russia, the legislation protects children, parents, especially parents with children who have disabilities. And then the last area that I want to speak to is representative bodies. So again, different countries have different frameworks. Most of the focus is on this is in Europe, where there are stronger unions, and places like Italy, where almost every employee works under a national collective agreement. Usually the works councils and trade unions have information and consultation rights. That means that companies have to share their plans with these organizations. The body usually has the right to request expert assistance, render an opinion, and in some cases they can even stop the process, or at the very least slow it down by taking it to court, where the courts tend to be much more employee-friendly and concerned with worker rights than the U.S. courts are. So seldom are there consent requirements, meaning that a union or a works council can outright stop the action, but it can definitely slow things down. So this is a really big thing that U.S. companies tend to trip on, and the consequences of failing to recognize the workers' representatives can be pretty significant. So finally, a few takeaways from my knothole. You want to make sure that you have some sort of baseline integration plan when you start working your due diligence process. So you want to begin with the end in mind. You want to know your end state, and you want to be able to then look at the requirements in those jurisdictions and make sure that you can do what you actually want to do so that your deal makes sense. I also highly recommend organizing your diligence and integration plans by jurisdiction, getting help from relevant local experts, and then just make sure that you allow extra time in the diligence and planning stages for the extra information and the complexities of the cross-border deal, and make sure that you budget extra time for any kind of required consultations.
Well, great. Thank you so much. Did any of our speakers have any closing remarks?
Well, there's a lot of information being shared. I hope people got bulk of it, and please, to the extent you have internal resources, call on them. If you don't have the internal resources, call people, your friends, your other business acquaintances, or call companies like Global Upside.
Great. Thank you so much. Doesn't look like we have any questions from our audience. So I would like to thank you all for a great presentation. I hope that everyone found today's discussion to be helpful and insightful. You can register for future Bloomberg BNA webinars by accessing our store at www.bna.com/learning. You will currently see instructions on how to earn credits for attending today's webinar. Please go to learning.bna.com to retrieve your certificate. COE certificates may take 4 to 6 weeks to appear depending on the jurisdiction requested. If you have any questions about continuing education credits, please email us at credits@bna.com. Finally, I once again thank Global Upside, our speakers, and all of you for your participation in today's webinar. Thanks, everyone, and enjoy the rest of your day.
Hang on.